Hello, everyone, and thank you so much for joining. I'm Sarah Reynolds. I'm the CEO of Silicon Valley Arbitration and Mediation Center and the managing partner of Goldman Ismail. SVAMC is thrilled for this opportunity to collaborate with our good friends at AAA-ICDR and to get an inside look at the AAA's recent commercial rule revisions. Many thanks to Bill Seward for getting us organized today, and to Mauricio Duarte, who is, in addition to being a very skilled moderator, is also COO at A2J Tech, which is a Colorado-based company that builds legal tech solutions to improve access to justice. And with that, I will hand it over to Mauricio.
Thank you, Sarah. And welcome to everyone, wherever you're tuning in, Central Time, Eastern Time, Pacific Standard Time, welcome. And we're just discussing about the weather, so hopefully the weather is better in your specific locations than my weather location in Minnesota. It's 25 degrees, so not fun. But I'm very excited for the panel today. We're going to be speaking about the update to the commercial rules of the AAA and the ICDR. We're going to be talking with different points of view. So before starting, I'm going to make the introductions of the panelists that we have here today. So I'm going to start with Sarah. Sarah, as you probably know, besides being the CEO of the Silicon Valley Arbitration and Mediation Center, she's also a managing partner at Goldman Ismail. As well, she's a fellow of the Chartered Institute of Arbitrators, and she has a vast catalog of experience in the arbitration world. In ICC, the Singapore International Arbitration Center, Hong Kong International Arbitration Center, and I can spend the next 5 minutes speaking about her experience. Now I'm going to introduce Jeffrey T. Sano, that he's the Vice President of the Commercial Division of the American Arbitration Association in New York. He oversees the administration of large and complex commercial caseloads. He also focuses on user outreach and on the panel of commercial neutrals in New York. He joined the AAA in 1990, and Jeffrey is dedicated to promoting ADR methods and its services. On the other hand, I'm going to now introduce Anne Ryan Robertson, and she, similar to Sarah and Jeffrey, has an extensive experience in the arbitration world. She's a chartered arbitrator, and she's the immediate past president of the Chartered Institute of Arbitrators and served as chair of the ICDR Rules Revision Committee, responsible for the 2021 ICDR Mediation on Arbitration Rules, which is going to be part of the subject of our discussion today. She's also an international partner in Lock Lord in the Houston office. She acts as an arbitrator and advocate in a wide variety of complex business disputes across numerous industries. And she's also the founding member of Arbitral Women. And now going with our final panelist, I'm going to introduce Aries Amaras. She's a full-time neutral in her own ADR practice. She has been mediating and arbitrating commercial cases for over 20 years, focusing on intellectual property, technology, and business disputes. She's also a fellow of the Chartered Institute of Arbitrators, and she has served as a neutral on an ad hoc basis for many organizations, including the AAA, the World Intellectual Property Organization, the U.S. Council for International Business, and many other organizations. So with that small introduction of our panelists, I'm going to get the ball rolling. And the first question I would say is just to lay the groundwork and the context about our main discussion. It's about the update of the rules from the AAA. So my first question is to you, Jeff. Sure. Again, considering from 2019, dynamics have changed, COVID happened. So why now did the AAA decided to update its rules? What was the reasoning behind it?
Sure. Well, first of all, I want to thank everyone for being here today. This is a wonderful, wonderful opportunity, and to talk about the updated commercial rules. Well, it's been almost 10 years. The last time we updated our rules was in 2013. We don't do it that often. It's something that we look at our rules as the gold standard in all areas. But a lot of changes have happened, like you mentioned. 2019 happened, 2020. In what happened in our community since 2013, a lot of things have changed with respect to cybersecurity, benefits of technology that we're starting to see, Third-party funding, that changed too, and we added that into our new commercial rules. Third-party funding has always been a big issue in the international community, not so much in the domestic community, but now we're starting to see more third-party funding in the domestic side. And also, like you said, the pandemic and virtual hearings and things like that. So we wanted to address that in the commercial rules. We also did a lot of things after 2013 internally at AAA, such as the Administrative Review Council. We talked about civility in the process, and selecting the chair was an issue that we were dealing with internally at AAA. We had policies internally at AAA, but now we said in 2022, we're going to take those things that we've been doing for the last 10 years as policy, put them into the rules, so there's a lot of transparency, and it gives our arbitrators like Harry an opportunity to point to the rule now and say, well, this is the rule for that area. Also, the economy has changed. We've seen the economy change a lot in the last 10 years, and the thresholds, therefore, and we're going to talk about that a little bit later, has changed for certain areas of the rules, such as the appointment of 3 arbitrators and what we deem at AAA to be an LCC case. So the economy had a factor, and also, and this is important, and we'll talk about this a little bit later on, the changes that we made in the other sets of rules. Now, you'll notice at AAA-ICDR, we never change the ICDR rules and the commercial rules at the same time. And we never change the construction rules at the same time. And why is it? Well, we're on different time patterns, but also it gives us an opportunity at AAA-ICDR to see what happened with these rule changes in construction or these rule changes in ICDR when we borrow off each other. So those are the main reasons why we said it's about time, and it was, I'm glad we did make the changes.
Thank you, Jeff. And now to understand a bit about the process behind updating the commercial rules. Again, you said we usually don't do that many updates. The last update was in 2013. Can you talk a bit about the process that it entails? And for that, I would also like to hear Anne's involvement in the process on updating or helping the AAA to update the rules. How does the committee that is doing the revisions, what is the involvement of the AAA, and how we get this output result that is the new revised rules?
Well, I'm happy to say I was not on the committee because that would have been a big time commitment, but they did a great job, and they did consult with all of us. It was a 2-year process to look at our rules, to update them. And we brought together a committee of staff, management, board members, and council members to look at our rules. And again, this took 2 years, a long process. We also reviewed case surveys. I'm not sure if the audience knows that we do surveys for all of our cases, and it's sent out to our clients. We also do internal surveys where our case managers, I'm included, we analyze our arbitrators and analyze the process. And we looked at those surveys. We looked at the client surveys. And then we also did interviews of our clients. Every year I do about 25 to 30 interviews of clients from large complex cases. I will call them up 6 months to 8 months after the case is completed and ask them various questions. And during those interviews, we started hearing some suggestions on tweaking our rules, making certain changes. And those interviews I found to be very, very helpful. Also, we, like I said before, we talk to our other colleagues in construction and in ICDR and employment. And in construction, we're going to talk about consolidation and joinder. That was a big area that we talked to them about. And we said, well, how's it been working for you guys? You guys have been doing this for 20 years, and we were considering it in the commercial area. So those areas, those kind of things help bringing all those people together. And it wasn't an easy process. And I'm very proud of the committee, what they did and their end product, effective September 1st, 2022.
Thank you, Jeff. And now the same question for you, Anne. You were on the other side of the coin. Let's speak about it on the committee side of the revision of the rules. So can you give a bit of context on how those discussions happen? What are some of the dynamics in order to create, let's say, an update of a complex, again, heavy lift that is changing the rules to new market needs, new trends from the users of the arbitration experience? So I want to hear your perspective, Anne.
Well, thank you very much. And I, like Jeffrey, thank you for this opportunity. For the ICDR rules, Jeffrey has explained it somewhat as the way we went about it for the ICDR rules, but there was something that was a little bit different. First of all, who was on the committee? The committee was made up of practitioners from around the world. We had one from China, one from Germany, one from England, one from Mexico, and then there were 3 of us from the United States. Some were act solely as advocate, some act solely as arbitrator, some did both, some had in-house experience. So we had a broad base of experience going into it. And the first thing we did was to look at the rules of all the other institutions to see if in fact they had anything that we thought would be an important change for us or that we might take and make better. And we think we took some and made some of those better. Then we talked about what we had personally encountered as problems and how we might want to address those. And I think it's important to mention that when we were redoing these rules, we were not just doing the arbitration rules, we also did the mediation rules. And the arbitration rules were last done in 2014, which is in accord with what Jeffrey said of it'd been about 10 years or close to it. But those mediation rules had not been revised since 2008. And they had not been revised with a view towards international mediation, which of course is something since 2008 has come to the forefront. We had 5 basic tenets that we attempted to recall through the entire process. One, we wanted to preserve the current language as much as possible, but at the same time, we made the language of the rules now gender neutral. In addition, we endorsed the UNCITRAL principles of how do you determine if something is international or not. And that's important because if you have an instance in which one of the parties falls within the UNCITRAL concept of international, although they have selected the commercial rules, they will then be administered by the ICDR. We also tried to focus on economy and efficiency. You will find that that is an important point that we have throughout the rules. And in addition to that, we tried to be innovative and last but not least, adhere to 2 important principles, those being integrity and transparency. And it took us about 15 months to do this. And once we had come up with the rules, they were sent internally throughout the entire AAA-ICDR organization for review and comment. And we also then sent them out to user groups to get their comments before we ultimately came up with the rules that were released in 2021.
Thank you for that, Anne and Jeff as well. And one thing that I take out of this, making the comparison now that I work in the technology space, is one interesting thing that you focused on, and is the user approach on updating the rules. Meaning you went with practitioners, have been directly in touch with users of the arbitration system to understand what are some of the changes, what are some of the needs, which I applaud you for that, because I thought that was lost in the legal world, but it sounds like in the arbitration world, we are very user-centered, or as a user-centered approach to changing the rules. But now moving on to some other general questions before we dive into more of the detailed provisions and updated changes to the rules. Probably from your perspective, Harry, as an arbitrator, and you have probably seen the changes that have happened, what are some of the, let's say, biggest changes that you have noticed on the rules? And then we're gonna probably go into a deeper dive on those ones, but at a first glance, what were some of the major changes that you noticed on the rules from the AAA in your experience as an arbitrator and mediator?
Well, I'm going to just point out 3. Rule 52, former Rule 50, that regarding modification to the award, it now permits any party with notice to the other parties to request that the arbitrator through the AAA interpret the award. That's in addition to what parties previously and or continually permitted to do, which is to request a correction for any clerical, typographical, or computational errors in the award. Another rule I'll point out is new Rule 8 on consolidation and joinder, which allows a party to file a request to consolidate 2 or more existing arbitrations into a single proceeding, or to request the joinder of additional parties to an ongoing arbitration. And the third that I think bears noting is Rule 2C, which incorporates the AAA-ICDR standards of conduct for party representatives. And I'm going to talk about each of these more later, so I'll stop there.
Thank you, Harry. And now going to the other side of the coin, from a council perspective, Sarah, what are some of the interesting changes that you have noted from the new update rules? And again, we also can discuss them in greater detail in the next piece of this discussion.
Sure. Yeah. You know, there's been just rapid change in how we practice law over the last 3 years, both from the pandemic and just other, you know, third-party funding moving further and further into the forefront of things. So these rules really are, as Jeff said, a reflection of how things have changed in recent history. And it's nice to have an updated set of rules to work with that are just better cued in to what we're actually doing these days. But as outside counsel, I would say that the AAA's, you know, first ever attempt here at commercial rules for consolidation of existing arbitrations and joinder of additional parties are a real benefit to practitioners. You know, this is one of those areas of law that, you know, it's about as thorny as they can get. It's a different answer depending on where you are. It's, you know, when one of these questions come in from clients, it's out, you know, your brain sort of starts to hurt because there's just never an easy answer here. And it seemed like one of those areas of the law where you just ended up doing a lot of work to tell your client maybe, because there was such a lack of clarity. And so I think the more that institutions can do to really clarify, you know, how to get this done, the better. And hopefully courts will, you know, eventually follow in with some, you know, fill in with some clearer guidance and more uniform guidance as well here in the United States. But I think I really like seeing institutions getting out ahead of this and just being explicit about how to get this done. I think that's really, it's such a complex area of law, and whatever we can do to introduce some clarity is helpful.
Thank you, Sarah. And both Ari and Sarah mentioned the consolidation and joiner. So I think now it makes sense to start diving deep into some of the specific, let's say, provisions or changes that were to the rules. So my first question now, to truly understand some of the changes in the context of those rules, Jeffrey, let's talk a bit about the added rule on consolidation and joiner. Can you elaborate more on this change?
Sure.
For the audience?
And I loved hearing what Sarah said, that there's more clarity now for your clients. That's great to hear, because consolidation and joinder did occur, obviously, with commercial matters, but it wasn't very clear. You know, you have to call the AAA and call the case manager and talk to the arbitrator, and it wasn't clear. Now we have Rule 8 specifically allowing consolidation and joinder. Well, why did we do that? Well, we were seeing it happening in the commercial world, not a lot, but we were seeing it happening. And like Sarah said, we didn't have any set guidelines on that. Construction has been doing it for years successfully, our construction division, over 20, 30 years. And I would say a good percentage of their cases are consolidated, or they have joinder or consolidation. Obviously, it's construction. We may not see that as much in the world of commercial, but we're seeing some. And Rule 8 explicitly allows a party to file for a request for consolidation or joinder. And it gives the AAA the authority, if there's not an arbitrator already appointed, to appoint an arbitrator to do that. Or even if there are arbitrators already on the cases, the 2 cases or 3 cases, we have the authority now to appoint a consolidation arbitrator. And that's kind of good that we have that authority. Will we see it a lot? I don't know. And where I'm hearing it, and I know we had a prep call, Harry and I briefly talked about this. We've heard some concerns from the employment folks, that sometimes the commercial rules are applied in employment disputes. And obviously there's class action waivers, so this becomes an issue. But our position at AAA, if you are coming under these rules, for a commercial dispute, yes, you're going to have those rights for consolidation and joinder. If it's an employment dispute, but under our commercial rules, it's not going to apply. So, but the history behind this is the reason that Sarah said, and that I'm saying that it's something that's been occurring anyways at AAA. Now we have a specific rule, Rule 8, for you guys to refer to, clients and arbitrators. And actually, we had, I can just mention this because one of my colleagues, I think, has joined our call today, Lisa Romeo in our Boston office. She had her first consolidation case today under our new rules, and we're starting to see things happening now under our new rules, which is exciting. They went into effect September 1st.
Jeff, and now from And Harry also mentioned that from your perspective as an arbitrator and mediator, that this addition was important. So from your perspective, what is the importance or what are some of the benefits of having now a consolidation and joiner provision in the rule?
Well, I'll step back a little bit and just start off by saying that, when conflict arises in complex transactions involving multiple contracts, it's rare for all parties to be signatories to a single contract with a single provision. You may have multiple contracts with different arbitration provisions, and it can be a real mess for the parties in particular, and sometimes for the arbitrator. The circumstances I just described raise the possibility that you're going to have common issues of law or fact that are going to be resolved in multiple arbitrations, increasing expense and time for resolution for parties, and the parties may end up with inconsistent results. And the same is true with joinder, where there may be inefficiencies in having multiple arbitrations involving various parties that are related to the same transaction or project, for example. So as Jeff has already pointed out, it provides the benefit that I see is it provides the parties an opportunity that they really might not have had before. I mean, right now, so they've got this opportunity, they can agree under the rules, and then that's it. But as Jeff said, it gives the authority to the AAA or an arbitrator to decide that issue for them. And the other thing that I think is really important is what I like about Rule 8. It's a very straightforward process. It's, pardon me, it's now uniform because it's part of the rules. So anybody at AAA, if there's a consolidation or joinder, there's one process to follow. And in the consolidation, with that issue in particular in Rule 8, it spells out certain very well recognized legal factors to look at in whether consolidation should occur. And that I think will help with the briefing. So when a party is briefing consolidation and using these factors, it's very helpful to have those factors as part of the rule, and as an arbitrator to be able to say, oh, these are really practical, acceptable factors that I'm going to use to decide. So those are, I think, all the benefits.
Thank you, Harry. And any final consideration from your end? Sarah, I know that you mentioned that it's a great benefit from a counsel perspective, but any other thoughts or benefits that you see from this consolidation and joinder provision?
Yeah, I mean, I think we covered it. I think my colleagues here have well covered it, but just being able to provide clear advice on this is a big win for outside counsel.
Yep. And the thing I like in here, you mentioned this, the standards are there in Rule 8. They're outlines. It's a long rule. It's not a short rule. And so that really helps the briefing process.
Thank you, Jeff. And now moving on to another big topic again. Jeff mentioned in his early introduction about why updating the rules, changes of market dynamics, economics, technology trends, and cybersecurity. So my question is for you, and from the perspective of the committee that was revising the rules, what were some of the discussions around technology and the need to update the rules, let's say the use of technology in the overall proceedings of arbitration? Can you give some context into what were some of those discussions and why, let's say, there was a consistent effort to push new rules on that realm?
Sure. The use of technology is not actually new in arbitration, especially international arbitration. We'd always had instances in which, for instance, a witness could not appear, and you would be able to let them appear virtually. However, what was required back then was you had to have a service provider to do it. It was very difficult to get it set up, and it was a great expense. Now everyone can do it from a laptop. So of course that changed things. And when the pandemic hit, I think most attorneys that were involved in arbitration at the time was, well, we just want a continuance. They were afraid of the new technology. We'll just take a continuance. But as it progressed and you're 6 and 7 and 8 months out, people are thinking, well, maybe I need to embrace this new technology. But then we have the issue of, well, does it affect the enforceability of the award if it's done virtually? And almost every arbitral institution, and the AAA-ICDR was no different, set out guidelines that said, yes, you can do virtual hearings. And to my knowledge, the few cases that now have tested whether or not an arbitration can be done virtually, the courts have all come down in favor of it being permitted, that it was not a basis of vacatur. So we had all those discussions as we were going through this, and we decided that in addition to the guidelines, that we wanted to make certain that it was in the rules as well. And if you look at Article 22.2 and 26.2, they specifically allow for video, audio, or other electronic means during the proceeding, and that the parties can agree to have a virtual hearing, or the tribunal itself, after having heard the views of the parties, can in fact order that it will be done virtually, so that the arbitrators still have control on this matter. And you also need to consider the fact that there's all sorts of cybersecurity issues that need to be addressed. And Article 22 sets forth in it that the tribunal is to discuss with the parties cybersecurity, privacy, and data protection. And in fact, for those of you who have arbitrated under AAA or ICDR rules, you know that you receive a list of cyber points that you need to address, and the arbitrators are directed to do so at the preliminary conference with the parties. And finally, Article 32 states that the tribunal retains the ability to direct that any witness's testimony may be done virtually and does not require the physical presence. So we have a whole series of rules, guidelines, and the like to not only assist the parties and their counsel, but also arbitrators in making certain that even if we're using this virtual world, it is a secure world.
Thank you, Ann. And from your perspective, Jeff, on the AAA and having discussions with clients, can you highlight at least some changes relating to cybersecurity, privacy, and data protection issues that is usually one of the concerns from clients?
Sure. Well, like Ian mentioned, the video technology was referenced in the rules prior to 2022, and we had a lot of questions when the pandemic hit about, do I have the authority as the arbitrator to rule a video conference or a virtual conference? And they did. Arbitrators always had that authority under our rules, but now we clarified it and elaborated on that in our rules about virtual hearings. And I think we actually even used the word virtual hearings as opposed to video conferencing. But we added in cybersecurity, privacy, and data protection areas into the preliminary hearing checklist. We have inside the rules, we put together a really great checklist in 2013 for both the arbitrators and for the parties to look at. And it's an elaborate checklist on what they should go over. And it just now requires that the arbitrator bring up cybersecurity, privacy, data protection in this process. And I don't need to criticize arbitrators that are sole practitioners, but they seem to be our weakest link at AAA. If you're in a law firm, you have those protections. AAA has our protections, but sometimes a sole arbitrator does not. And so what we did prior to the pandemic is we started doing cybersecurity boot camps, bringing in our arbitrators to various offices throughout the country and talking to them about cybersecurity, looking at their laptops, looking at their handhelds and their iPads and things like that. And from those conversations that we had prior to 2022, when we introduced the new rules, a lot of stuff came up about cybersecurity, privacy, data protection. And so now it's in the rules, and the arbitrators can cite it in the preliminary hearing, bring it up, and we encourage them to do that. And they have been, and they've been doing it before that. But now, again, like we said before, it's in the rules, and it's specifically in the rules. And it makes people think about it, that it's referenced in the rules. Like, for example, in 2013, when we put Rule 9, now Rule 10, about mandatory mediation. That made us think about mediation at AAA, made our clients think about mediation. Did a lot of people take us up on it? No, but it made us, able to talk about it a lot more to the clients, made clients feel like, okay, there's an option here for mediation. Same thing with cybersecurity, privacy, and data protection, bringing it up, putting it in the rules, making sure people are talking about it. Really important, I think.
Thank you, Jeff. And consider to say this discussion, not only the background context from Anne and also Jeff's perspective, Sarah, from your point of view as a counsel, what are some of the, let's say, impacts that we'll see in the arbitration proceedings with this new set of proposed changes around technology?
Yeah, sure. So I think, what this does is in some ways confirm what we all know, right? Is that these changes in how we conduct arbitration work as a result of the pandemic are going to persist well beyond the pandemic, that these tools and this way of conducting arbitration hearings and other elements of the arbitration process are here to stay, which I know a lot of my clients really liked being able to do these hearings remotely, particularly smaller hearings, without having to travel and drag both their company people and other witnesses and experts all around the globe off, just the cost savings for clients is immense. And the technology, frankly, has gotten so good that you're not really losing much by doing things virtually at this point. And so again, the more confirmation we have that it's okay to continue this way is good. And taking just the example of an expert, once upon a time pre-pandemic when everything was done in person, if you had a long hearing and you had an expert that was testifying at that hearing, you generally had to fly them somewhere. They had to sit and wait for a few days for their turn to testify. And so you had clients who were paying these very high hourly rates, for what would ultimately be a few hours of testimony, but they were paying that rate for days. And that's gone now, right? Now your expert zooms in for the 2 or 3 hours that she or he is going to testify, and they're out. So you're paying for 2 hours. You're not paying for days. And so those cost savings are just, it's really hard to argue that there's a benefit that outweighs that for clients. And as the technology has improved to a point and continues to improve to a point that it's here to stay, and I think these rules are just acknowledging that those changes are going to persist, that these weren't temporary measures. These are the way things are done now.
Thank you, Sarah. And from your perspective now, Harry, as an arbitrator, and Jeff mentioned that sometimes arbitrators could be the weakest link. Now that you are, but understanding your perspective on some of the new proposed changes on technology, how do you navigate those as an arbitrator, and what are some of the impacts that you have noticed or you think you're gonna start noticing with the new proposed changes around technology?
Well, I'm going to mention 3 of the 3 relating to technology. Rule 22, which includes the use of video conferencing as a method for conducting the preliminary hearing. That to me really reflects what's becoming more of a norm. And that is post-COVID, there's been a big uptick of using video conferencing for conferences like the preliminary hearing and even status conference or dispositive motion issues before. And it really promotes what I like about it, and folks that other arbitrators I sit with, it allows the clients to get to know the arbitrators that have been chosen, as well as counsel. And sometimes I find that it's very helpful. I can read facial expressions, I can read body language, things that help me to communicate better with counsel and to understand hesitations, concerns, whatever. So I really like that. With regard to Rule 25 and Rule 33, both that relate to the method of the hearing and the conduct of the proceeding, this has already been said, but I'll just say that since the AAA and arbitrators have really been interpreting those rules to allow an arbitrator to order the use of technology to either facilitate a witness attending remotely, or even post-COVID having the entire hearing online, I think by expressly providing an arbitrator's authority to conduct hearings by video conference, it gives advocates and clients clear notice of an arbitrator's discretion to hold the entire hearing by video conference. And so there's, I think that's important and gives me it kind of makes it more of a slimline process, if you will, to be able to get to that point with it being expressly there. The other thing I'll mention, the last one, is Rule 29, formerly Rule 28, the official record of the proceedings. This updates, the updates to this rule allows a party to request any form of transcribed record or other recording. I have never used anything but a reporter, court reporter, so to speak, during an arbitration. But I do know that at least, and I don't know anybody that's just done an audio recording, but I bring this up because I think it meets the question that you raised, which is if parties or the panel proceed with only an audio recording of the hearing, which they're permitted to do now, they may want to consider putting into place a protocol for how and when such a recording is made, so that what they intend to be recorded is recorded. And particularly if the recording, an audio recording, is the only formal record of the proceeding. So that's kind of an issue that I think people need to be aware of with the expansion of that rule 29.
If I could just say one thing.
Yeah,
Harry, I like what you said about like the further use, even if it's not the evidentiary hearing. I'm seeing more and more of our arbitrators for the preliminary hearing doing it via Zoom or via virtual platform. Yesterday, I had a panel of 20 arbitrators, and I asked them to raise their hand. And almost everyone raised their hand if they do preliminary hearings now via Zoom. And I think it's more effective. You get a chance now to see your counsel. You get a chance potentially to see the client early on. So that's a silver lining of the pandemic, I guess.
Yeah.
Thank you, Jeff. And what now going to another provision that sometimes now it is being questioned with a digital space in a digital world is confidentiality in arbitrations, Jeff. And sometimes, again, there's a misconstrued notion that because something now is digital, it's not confidential, but I think it's completely the opposite. But again, to clarify that, I know that on the new updated rules of the AAA, there's provision regarding confidentiality. So can you give some context as to that provision and what
Sure.
does it entail to serve?
Absolutely. It's a new rule 45A incorporates confidentiality. Now, we've always had the code of ethics for arbitrators. They've always had the confidentiality requirement for any case that they handle, be it with the AAA or not with the AAA. And same with the AAA. We've always had these confidentiality requirements at AAA. We cannot talk about any case. I can't talk about any case with my family members. But I think that, the big reason we did this was now the arbitrators have the authority to, they can point to a rule and say, if one side is requesting something to be confidential in the process, they can say, well, it's here in the rule. Have they been doing it in the past? Yes. A lot of arbitrators have done this in the past, and they've ruled things to be confidential. The process, as we know, is private, but it's not confidential. Okay. So now we have it in our rules. They can make a reference to it. I think it's a good thing. But again, like I said, it was happening before in the past, but now it's a rule that we can cite, and we're bound by it, AAA. The arbitrators, Harry's bound by it as a AAA arbitrator. However, now she has the authority to make a ruling on that with respect to trade secrets, let's say, or something like that. And we're seeing it more and more. But I think to your point about the virtual world, I think, we have standards now. A lot of arbitrators say, you have to sign it, you have to make sure this is a confidential process. Some even make people take the cameras and look around the room and things like that. So there's various procedures at the beginning of the process, but I think it's a good thing. It's now in our rules. I really do.
Thank you, Jeff. And Harry, I know that confidentiality usually is a big issue that arbitrators take into consideration. So my question to you is, how might arbitrators now use their revision to Rule 45 to maintain the confidentiality of arbitration proceedings? Are there any concerns? Are there any things that, from an arbitrator perspective, you have to be aware of? Just trying to understand your perspective on this new updated rule.
Sure, I agree with everything Jeff said. I'll only add that it's very common in the cases that I do. There are a lot of technology cases or business confidential information that the parties will agree straight on. I'll raise it at the preliminary hearing with to have a protective order in place. And typically the protective order covers the information exchange part of the case, as well as using the information, documents and other information during the proceedings. So what I like about it is that it, I think, since many people, as Jeff says, probably are already using protective orders to protect not only the use of confidential information during the proceedings, it also, though, there's sometimes when it starts a conversation, because believe it or not, there are sometimes very sophisticated people and attorneys out there who kind of think it automatically, that because it's arbitration, it's automatically confidential. They don't understand that, we always say it's a creature of contract, and they don't understand that that's a mechanical part of the arbitration. So I like that it's in there. I think it will start a conversation between counsel and counsel before the preliminary hearing. As Jeff said, it's something I can clearly point to, raise it as an issue to be discussed, meet and confer before the preliminary hearing, and certainly cover it afterwards. It's right there.
Thank you, Harry. And with that, again, I know that we have talked about different topics, but now I want to go to something I would say a bit outside the usual stages of an arbitration, and it's regarding the Administrative Review Council. So when the rules now incorporate the Administrative Review Council, and I'm assuming this was a discussion during the committee. So can you explain a bit what this Administrative Review Council is, and why is it now in the rules? What were some of the discussions that incentivized the addition of this new body in the arbitration proceedings?
Be happy to, and you're going to find this at Article 5 of the ICDR rules. And IARC, which is what we call it, is actually not a new concept. Been around for quite some time. But the reason that we included it in these rules goes back to one of the tenets that I talked about, and that was transparency. We put it in the rules so that the attorneys and parties would understand just exactly what IARC is and what its function is. IARC is a 3-member panel, and it's composed of current and past executives of the AAA-ICDR. And they meet every Tuesday. And they're called upon to actually address 5 different situations. The first situation might be that there's a question as to whether or not the administrative filings that have been made with the Institute have been met. And the IARC's decision on that particular issue would be final. The next one is the number of arbitrators. If the parties have not in their provision put what the number of arbitrators should be, and if it doesn't fall under expedited rules, for instance, then the IARC is going to make that decision, and that decision is also final. The next one is the one which is most prevalent in the user's mind, I think, and that is challenges to the arbitrator. And at any time there's been a challenge to an arbitrator, that decision is also made by IARC, and that decision is also final. Then you sometimes have instances in which the parties have failed to designate the seat of the arbitration. In other words, the place of the arbitration. And in this instance, the initial determination of that is going to be made by IARC. However, where the seat will be is ultimately the final decision of the tribunal. So this is one instance in which IARC is not the final say of what's to occur. There is yet another instance, and that is anything else that appears to be administrative that needs to be elevated, it too would go to the IARC. So the reason it's in the rule, as I said, is to provide complete transparency. For instance, on the arbitrator challenges, if you're an arbitrator and you have been challenged, you may be contacted by the case manager asking for additional information. And that is because IARC has felt they need additional information in order to make a determination as to whether or not the challenge should stand. But it goes back to transparency. We really want to keep the process transparent and have it to have great integrity.
Thank you. And Jeff, anything to add on from your end?
Not much. Anne really covered it. I mean, on the domestic side, very similar. Those 3 areas that she talked about, locale, administrative fees, and removal of an arbitrator, those are decided every Tuesday, like Anne mentioned, by a commercial domestic side of 5 executives. I think it's a great thing. It's been around since 2013. I'm a big advocate of it because as a local vice president in New York, I used to make these decisions, not on my own, but sort of in a vacuum, where I would consult with our legal department, and they would give me some advice. But then sometimes I would hear different decisions being made on the West Coast as opposed to what we're doing on the East Coast. So now we have an administrative review council that has consistency. And now it's in the rules. And like Ann mentioned, and Harry mentioned, and Sarah mentioned, there's transparency now in the process. You can point to that rule. It was always there. We had guidelines on the web page at AAA, guidelines and standards for the Administrative Review Council. But now specifically it's in the rules. I don't have to say to a client, do you know about ARC, the Administrative Review Council? It's there. It's in the rules, and it's a good thing. It really is. And we meet every Tuesday, like Ann said, and we have a number of cases, I think over 300 cases a year internally, in just commercial domestic. I'm not sure about ICDR.
Thank you, Jeff, and thank you, Ann. And now I want to skip to a different profession that might be interesting, that not necessarily every arbitration center has something like this. But now, Sarah and Harry, I would like to hear your perspective on this. And is now the AAA rules incorporate the standards of conduct for parties and representatives. Obviously, as counsels or some arbitrators, we know the importance of acting, let's say, in a professional manner during the arbitration proceedings. But what are some of the positive outcomes that you foresee out of the changes on this provision? And maybe I would like to start with Harry, and then I can go with Sarah's perspective.
Sure. I think when I stood back and I thought about it, it's, the AAA administers and arbitrators provide over such a wide array of cases, with counsel having different experience levels in arbitration, with clients, sometimes you have cases where the client is not represented by counsel. There's so many. And so I think there are at least two benefits that I see with this change. One, it simply raises the profile of the standards and the attention to be given to them. And I think that's great. I think it sets a professional tone for everybody, but maybe in particular for folks who are not as accustomed to arbitration as others. Second of all, and this is important, I think, from the arbitrator standpoint, but also from a party standpoint, it gives teeth to the standards. So if they're in the rules, and I may consider in the future having a line item, that, certainly we always say that, these are the rules that apply. And typically my cases are commercial cases, so the commercial rules apply. But if I may decide to have a separate line item that says, that we're following as per rule such and such, these are the standards. And if there is a violation of the standard, it may help give some basis, if necessary, for discipline, or at least a warning or a reminder. So that's how I see the benefit of the change.
Thank you, Harry. And now, Sarah, from your perspective, that you have some of the burden on acting accordingly to those standards, what is your perspective?
Well, and it's been it's become thematic at this point, but I like clear standards. If you haven't gotten that yet, but you'll get it here. So arbitration has always been a comparatively white glove practice compared to traditional litigation. And you do occasionally see some unfortunate deterioration in decorum. I think, like Harry mentioned, it's often people who are sort of moonlighting as arbitration practitioners who didn't grow up in arbitration, but are really litigators that are stepping into arbitration, that that don't sort of understand. We have a lot of sort of implicit standards that aren't clearly stated anywhere. And so in these rules aim to sort of make those things explicit, that there's a high standard for conduct in arbitration. And what I like about it is that it gives counsel a basis to call out bad behavior, and the same thing for arbitrators. It gives them a basis, sort of a ground on which to act in response. Because even when, if someone was sort of behaving short of lying or some kind of fraud or deceit, where you would feel obligated to raise it in almost the form of sort of a motion to the arbitrator, when a party's just being sort of rude or unnecessarily difficult, it's really hard to complain to the decision maker about that. They're being mean, they're being rude. it's nobody wants to be, no lawyer wants to be making that complaint. Where this makes it much easier to say, well, they're violating this explicitly stated standard. So it's a little easier to sort of do something about it, instead of just, where I used to always take the tact like, yeah, they're being sort of obnoxious, but I'm just going to rely on and sort of hope that the arbitrator is seeing it too and reacting to it the same way that I am, and I don't really need to raise it because they're seeing it. And this sort of gives sort of both sides, both the other parties, counsel and the arbitrators, sort of teeth or grounds, as Harry said, to actually explicitly, make a statement about it.
Thank you, Sarah. And to start wrapping up the event, I know we have 9 minutes left. I want to do one final question to end specifically, and then we can go for final considerations about the changes. And again, this comes by saying to the audience that if you have any questions before we wrap up the event, you can use the QA option at the bottom of your screen. You're going to see on the navigation bar a Q&A function. So feel free to submit any questions before we wrap up the event. So, and just to wrap up again, some of the changes in general, let's say, provisions that were added. Was there a particular consideration in the committee to push changes concerning discovery, motions, and the conduct of proceedings in expedited procedures? That I know is one of the biggest debates in the arbitration world on how can we truly make expedited procedures expedited? How can we avoid that an expedited procedure becomes a normal arbitration proceeding with a lot of motions, and on the discovery phase or the evidence stage of the arbitration gets very long. So trying to understand some of those changes and how that discussion happened from the committee perspective.
Well, and the expedited rules, of course, have stood the test of time and have been in the ICDR rules for a number of years. What the committee did address is the scope. In other words, when will they be applicable? And previously, it was $250,000. If a case was that was an issue either in the claim or the counterclaim, and it was $250,000, you'd be under the expedited rules. That has now been raised to $500,000. And I will say that there was discussion in the committee to raise that to an even higher limit, because if you look at some of the other institutions, they in fact do have a higher number as it relates to their expedited proceedings. However, if you also look at the other institution rules, their expedited proceedings are not necessarily as expedited as they are under the ICDR. So you have a couple of points you have to consider here when you're looking at the expedited rules at the ICDR. First of all, even though we made it a threshold or an upper limit of $500,000, parties can always agree to go under the expedited procedures if they want to. In addition to that, under the ICDR rules, the estimated cycle time from beginning to the award is 135 days. It requires a party to put in a detailed submission immediately. The arbitrator list has to be returned in 10 days. The procedural hearing and order is due 14 days after the arbitrator is appointed. If in fact the amount at issue is $100,000 or less, your hearing is going to be done on written submissions only, and that hearing is to be 60 days from that order. If it's to be an oral hearing, again, you're under that 60-day. And then, of course, and this is shortening for the ICDR, although this is the number you have under the AAA, that is that the award is due within 30 days of the hearing. So it's a very compressed process. And that's one of the reasons why we raised it to $500,000. We thought that if we raised it even higher, it might cause some issues from some parties. And those that want expedited hearing can always request and agree to them.
Thank you. And again, the final stretch. So I now want to just get final consideration from the panelists, and I can thank you everyone, not only the audience, but also the panelists that have shared their insights. I have find it very valuable, although I'm retired from the arbitration space now for 7 years. It's interesting to always refresh some of the new trends on the practice side. So Sarah, let's start with you. From a practical perspective, let's be pragmatic as counsels. In my past life, I always focus on let's be pragmatic. what are some of the challenges from your perspective that you envision with the new rules? Do you envision a challenge with other councils adequating to the rules, the use of technology? What are some of those challenges that you foresee with the new updated rules from the AAA?
Honestly, I'm really excited about these rules and I think they're very well done. I suspect that they will be, refined, practice will be refined over time to make them even better. But like with all new rules, it takes some time for them to be triggered. So we'll be operating under their old rules until clauses agreed to sort of post the revisions going live are triggered. And so one of the challenges for me in these sort of circumstances is wading through the current disputes in the meantime without being able to take advantage of all the great changes that are in these revisions. So we'll all have to be a little bit patient before we can really try them out.
Thank you, Sarah. And we do have one question, and this could be a great segue to you, Jeff. And
Okay.
Gary Benton asks on the chat, and he says, I'm sure you'll agree that a good arbitration depends on more than good rules. Quality administrators and arbitrators are critical. And what's key to making AAA-ICDR provide a better experience than its competitors, Jeff?
Sure. Well, I'm not going to mention our competitors right now, but some of them are structured a little bit differently. The way the AAA is structured, we're a not-for-profit. Our case managers and myself, we work for the parties. We don't work for the arbitrators. We're not assigned arbitrators, unlike some other competitors. We directly work for the parties. So our interest is the parties. And so I think that's the biggest area too that at AAA. And if you deal with AAA, you'll see a lot of longevity with our case management staff. They've been with us for a long time in the Northeast and the West Coast. Myself, I've been with the AAA for over 30 years. My colleague who's on the call right now, Lisa, has been, I think, 32 years, or, there's a lot of longevity at AAA. And, again, the not-for-profit issue and the way we're structured to focus on the parties, not the arbitrators. We don't answer to the arbitrators. We love our arbitrators. We do. We think they're the best. However, we don't work for them. We work for the parties.
If I might add one thing, and I'm going to put on my party hat at the moment as not a happy birthday party hat, but a party hat, as opposed to arbitrator. And that is the fact that you have the preliminary conference with the AAA or the ICDR before the arbitrators are ever appointed. So you have met the case manager. The case manager is already investigating what some of the issues may be in the case. It guides them if they have to come up with a list of arbitrators. I think it's an excellent touch point, and you don't get that with any other institution.
Great point, Ian. Definitely great point.
Thank you. And now to wrap up from your perspective, Jeff, and what are some, let's say, provisions that you think either arbitrators or counsel should be aware of, that they should consider, that they should take a closer look now that the new updated rules have happened? What would you say, Jeff or Ann, either one of you?
Yeah, just two quick things on money. Remedies for non-payment by one party, that's in there now. That wasn't in there before. Cost allocations for emergency arbitrations, where, in dispositive motions, if it's not done in good faith, now the arbitrator has some teeth, some authority to say the cost shift is going to shift to the other side. Very important on the cost issues.
I'd like to add what Jeffrey said, and many of those things that Jeffrey said are incorporated in the ICDR rules. Yep. But one of the issues that has been basically a hot topic, especially in the international community, is the use of tribunal secretaries. And you will find in our rules now that we say at Article 17 that the tribunal, with the consent of the parties, may appoint a tribunal secretary who will serve in accordance with the ICDR guidelines. The guidelines my committee also worked on, and I'm happy to say they have now been published effective December 1st of 2022. And there's a couple of key things, and I took this from my own personal experience. Whether or not a tribal secretary is going to be used or not, that question is going through the case manager. So that if the tribunal members want to have a tribunal secretary, they alert the case manager, they provide the CV, they provide the rate, and then the case manager interfaces with the parties, and the parties make their objection to the case manager, so that the arbitrators are not aware of who is objecting to the use of a tribunal secretary. I've personally pushed for this rule because I found myself in situations in which, after the chair has been appointed, all of a sudden it's King's X. Oh, I use a tribunal secretary. It's going to cost this amount of money. Do you object? Well, at that point, you have been put in a very difficult situation, because if you object, it may not consciously, but unconsciously affect that arbitrator's decisions in the case or impressions of the party. So everything is going to be going through the case manager. The tribunal secretaries are to be paid on an hourly basis, and they are subject to the very same code of conduct as the arbitrators.
Thank you, Ann. And to wrap things up now, Harry, I want to hear your perspective. What would you say is one thing that arbitrators should be aware of, or it could be councils as well, but one final thought from your perspective on the new updated rules?
Sure, I'm going to say Rule 52, that the modification to the award, which now permits any party on notice to the other parties through the AAA to interpret the award. I think that that'll be interesting to see how that plays out. Two things to keep in mind is that, as per the rule, the arbitrator is not empowered to redetermine the merits of any claim that's already been decided. So if the arbitrator is considering interpretation, it should not redetermine the merits. It needs to make sure that it's in a very narrow lane. And the arbitrator does not have to grant the request. So it's something to keep in mind. I'm sure that it may cause arbitrators to redouble their efforts in reviewing the awards before they go out, to make sure that they're not inviting in any way a request to interpret. But that'll be interesting to see that rule and how that plays out over time.
Absolutely.
Sounds good. Thank you, Harry. And I want to be respectful of everyone's time. So I know we have come to the end of, let's say, the hour that we had allocated for these events. So before wrapping things up, I want to again thank everyone that joined us today. I want to thank for the investment of your time. And I also want to thank the panelists for joining us today and sharing their insights. From my end, I just want to, let's say, invite you all to keep posted on the Silicon Valley Arbitration and Mediation upcoming events. We're also going to have a discussion about arbitration and entrepreneurship next week. I'm also going to be moderating that panel. It explains a bit about my path. So hopefully you can all join us in all the future events from the Silicon Valley Arbitration and Mediation Center. So I hope you have a great week and a great holiday season. So thank you, everyone, and take care.
Thank
Thanks,
you.
Mauricio. Thanks, everyone.
Thank you so much, guys. Appreciate it.